Dear listeners, welcome to the quarterly podcast of TRUSTS, Trusted Secure Data Sharing Space, an innovation action funded by the EU Commission's Horizon 2020 Research and Innovation Programme. Today's interview partner is Yuliya Miadzvetskaya, Research Associate at the Center for IT and IP Law at the Catholic University Leuven. I would like to give the listeners who are with us for the first time a short outline about the project before we start. TRUSTS aims at creating a secure and trustworthy European data market and platform federator for personal and industrial use by interconnecting different user groups and providing generic functionalities for innovative applications and services. A specific legal framework that protects relevant data from unauthorized use is urgently needed. At the same time, this framework should not put European businesses at a disadvantage in global competition. Yuliya and her colleagues from KU Leuven are responsible for developing such a legal and ethical framework for a platform and platform federator like TRUSTS. Many law experts call the juridical situation concerning data transactions a legal patchwork. Dear Yuliya, where do you see major voids and controversies concerning the legal situation when it comes to data sharing?
Hello, Nina, and first of all, thank you very much for having me here today. And in response to your question, I will say that we know all that now data is often referred to as a new oil, new resource, new infrastructure, even the fifth freedom of the EU internal market, just like goods, capitals, and services. The free movement of personal and non-personal data is, of course, of a strategic importance for fostering the EU data-driven economy. However, now we see that the main difficulty is the fact that, as you mentioned earlier, this legal framework which governs data transactions is a legal patchwork, actually. So it comprises several legal acts, and sometimes it's difficult to know how all of them interact with each other. First of all, we all know that there is the GDPR, which is the most famous, I would say, legal act when it comes to the EU data-related legal framework. It's the cornerstone of this EU data-related legal framework. But of course, when it comes to data transactions, we shall not be only limited to personal data and to the GDPR, and we shall reflect also on other ways how data can be regulated. And that's exactly what is happening now, because we see that the European Union regulators, they have shifted their focus towards other ways of regulating data. Notably data sharing, data reuse, or even making the data available in order to enable a functioning digital market. And that's something which is foreseen also in the European data strategy, which was released last year. And of course, the main purpose is to transform the EU in a leading data-driven society and create a single market for data. Apart from the GDPR, there is also the regulation on the free flow of non-personal data, which aims at removing obstacles to the free movement of data across the EU. And it prohibits member states from imposing data localization requirements, of course, unless they are justified on some considerations, such as public security grounds, for instance. But we all know that the main difficulty is, of course, to draw a line between what qualifies personal data and what qualifies as non-personal data. Because in accordance with the GDPR, the notion of personal data is rather broad, and it encompasses any information which is relating to an unidentified or identifiable natural person. But at the same time, due to technological developments, it's not excluded that at some point, non-personal data or anonymized data can be turned into personal data. So this is the concept of personal and non-personal data are both dynamic ones, and data can change its nature from personal into non-personal and vice versa. Another difficulty when it comes to data related legal framework is to actually regulate mixed data sets. Or when it comes to mixed data sets, these are data sets which are composed both of personal and non-personal data. And the regulation on the free flow of non-personal data applies only to the non-personal data part of the mixed data set. But the question is how this shall be regulated when data sets are inextricably linked. So when it's not possible to actually draw a fine line and to know what is personal and what is non-personal, because they're inextricably linked. In this case, the GDPR will prevail, and even non-personal data will be treated as personal data. The Commission followed up on this issue, and it published some informative guidance on the interaction between the regulation on the free flow of non-personal data and also on its intersection with the GDPR when it comes to mixed data sets which are intrinsically linked. Apart from those both legal acts mentioned earlier, there is also the Open Data Directive, which is in force since 2019, and its main aim is to allow free reuse of data which is held by national public sector bodies or certain public undertakings. And this directive, however, does not apply to data for which third parties hold intellectual property rights. And when it comes to its intersection with the GDPR, the Open Data Directive does not prevail over the GDPR and only applies to data that is not personal. But we all understand that those legal acts are not enough, and other legal instruments are needed for ensuring the free flow of data in the European Union. And in November last year, the Commission put forward a proposal for a Data Governance Act that regulates data sharing intermediaries, data altruism, international access to EU-based data. We also already noticed, of course, this is just a proposal for a new legal framework, but already this proposal raised a number of questions and concerns, in particular on its interaction with the GDPR, because, for instance, some data processing principles which are enshrined in the GDPR, such as purpose limitation principle, they are difficultly compatible with the objective of stimulating data sharing in the European Union.
Okay, I see. So definitely there are many regulations, but could you kindly tell us more about the Data Governance Act and what it brings in terms of fostering data sharing in the EU?
Yes, of course. So the Commission issued a proposal for the regulation on data governance. Now this legal act will be discussed by the European Parliament and by the Council as well. It will go through this famous process of trilogues, and of course it's not easy to comment now on the content of this legal act because it can still change after trilogues. But we already see that with this Data Governance Act, the Commission wants to supplement the Open Data Directive, which, as mentioned earlier, applies only to data held by public sector bodies, for which there are no intellectual property rights. So with Data Governance Act, the Commission aims at fostering and enhancing data sharing for other types of data, such as commercially sensitive or highly sensitive data. So I can single out 5 main elements of the Data Governance Act. First of all, these legal frameworks covers the reuse of certain types of sensitive categories of public sector data. Secondly, it introduces a novel type of data intermediary, so-called data sharing services providers, which are specialized parties that help data holders and data users in transacting data, such as data marketplaces, data trusts, or data sharing service providers. Then the Data Governance Act also aims at fostering this new concept of data altruism. So fostering data sharing in some specific fields, like the medical field. And also the Data Governance Act provides for the establishment of the Innovation Board, which is an expert group which is composed of representative of competent authorities of member states, of the European Data Protection Board, of the Commission, and their main objective is to reflect on the new practices and to develop new consistent practices actually on how the Commission can further regulate data sharing across the European Union. And of course, one of the, I would say, most important dimensions of this Data Governance Act is its international dimension, notably international transfers of highly sensitive data. And we can already see that there is a certain closeness to how it's done under GDPR, because when there is a transfer of a highly sensitive non-personal data to a non-EU country, there is also a need to make an assessment of the legal framework of whether this highly sensitive non-personal data will be subject to intellectual property rights in the third country, for instance. In addition, there is also an obligation to put in place legal, technical, and organizational measures to prevent law enforcement authorities to have access to EU-based data unless certain conditions are fulfilled or unless there is an international treaty in place. And also another interesting aspect of the Data Governance Act is an obligation to impose a legal representative in one of the EU member states for a data sharing services provider which is not established in the EU. So we can see that there is a shift to actually hold EU data in the European Union and to protect EU-based data. So to make sure that it benefits really the European economy and European businesses and citizens.
Okay, I understand. Thank you for those explanations. But in this context, how will trusts help the EU policymakers to tackle the legal framework with regards to data transactions?
So in our research at KU Leuven, we want to reflect on the notion of trust, notably to enable those data transactions on the data marketplace, because trust still remains the main problem. Companies hesitate to share data because they are not sure that this data will be used for agreed purposes. And furthermore, data subjects are also afraid of their personal data of being misused. There is also an enforcement question, trust in actors and fulfillment of their contractual obligations. So we consider that the main mission of the KU Leuven will be to inform EU policymakers on a set of legal arrangements to make the data sharing easier in the European Union, and also reflect on some potential legal rules which can be foreseen, such as codes of conduct, and also reflect on how common European data spaces can be regulated, and notably the platforms such as TRUSTS.
Okay, I understand. And if I may come in here with a more generic question, would you say that the law can be used as a transformative power for enhancing the EU digital strategic autonomy?
Yes, absolutely. Absolutely. I think sometimes we have this general feeling that Europe or the European Union is a powerless entity which is unable to speak with one voice at the international scene. But I totally disagree with this approach, and I believe in the idea which was advanced by Anu Bradford in this concept of the Brussels effect, and in the fact that the EU is actually one of the most powerful global actors in the field of digital regulation. And this is completely true when we look at the role that the European Union played with its GDPR, how the European Union became a global regulator, setting standards for others. And I think this is the objective that the European Union shall aim at achieving also with the Data Governance Act, to be an international rule maker for the globe instead of being a rule taker. already we see now that with the Data Governance Act, the European Union will preserve the EU's data and in the European Union and prevent foreign governments potential access to European public and private sector data. We all know that at the moment the Commission is working on making sure that the restrictions on access to EU public sector data are compatible also with WTO rules. And there is also a question with respect to data localization requirements to keep certain data sets in the European Union for security reasons. And for the European Union, the next step would be to check whether what is foreseen already now in the Data Governance Act, whether it's compatible with international trade obligations undertaken by the European Union under other legal frameworks. So to make sure that the European Union does not violate its own commitments elsewhere.
I see, okay. And what is the specific role of researchers like you to contribute to a faster progress of European law in that context?
Our main role is to look critically and holistically at the EU legal framework in order to detect controversies at the earliest stage possible. Within the framework of a research project such as TRUSTS, we can test, we can try out different solutions and approaches. We can also, we shall avoid this patcher, but we can even make mistakes because it's we are learning by doing, and this gives us a lot of freedom, academic freedom first of all, and this is a real privilege for any researcher. And we can also, and we hope to inform policymakers, EU policymakers through our publications and contribute to this new body of European law when it comes to data transactions.
Okay, very interesting. Thank you for that, Yuliya. With that, we are also at the end of our podcast. I would like to thank you very much for your time and the very interesting information you provided for our listeners and to me. I'm very looking forward to further collaborate with you within TRUSTS. So thank you once more. And dear listeners, thank you very much for keeping up with TRUSTS progresses and results. On our website and social media channels, which you can find in the descriptions, we offer informative blog posts, podcasts like this one, and also invitations to hands-on workshops and webinars. Follow TRUSTS to keep up with European innovations.